Greetings to all. This is Vidhya Balasubramanian, Assistant Professor, Department of Business Administration. I'm going to talk about the topic breach of contract. A breach of contract means it's a breaking of the contract between the two parties, which seems that this topic can help the students can understand the basic legal terms of breaking the contract, and this show that what are all the compensation we can give to the injured party for the damages. So here the injured party means is a wounded party who is not in the party of a default. Next, breaking of the contract. Breaking of the contract means we can say that if any party refuses to perform the contract, that contract will get a breaking between the two parties, that is both buyer and the seller. We can breach the contract in two ways, like anticipatory breach and actual breach of the contract. We can say the anticipatory breach of the contract means if the two parties involved in the contract at the time of the performance, that is before the due date of the performance, if any one of the party refuses to not performing the contract, that is called anticipatory breach of the contract. We can say with an instance, that is Peter agrees to sell 100 bags of sugars to the John on the agreed day. So, if the Peter need to sell the 100 bags of sugar to the John before the on the time of the due date, if such party, that is a Peter, may not sell the 100 bags of sugar to the John, that party can communicate before the time itself that couldn't able to supply the goods. That type of the contract is called anticipatory breach of the contract, because we can say that priorly we should not say that we can not supply the goods. In that type of breach is called anticipatory breach of the contract. Next, we can say that actual breach of the contract. Actual breach means it can be segregated into type of the meanings, which is called on due date of performance and during the course of the performance. We can say that actual breach of the contract means at the time of the performance on the agreed day, if any one of the parties doesn't supply the goods to the opponent party, at the time of the performance only they are informing the buyer that he or she couldn't supply the goods. That type of breach is called as an actual breach of the contract. Next, we can say that remedies for breach of contract. Remedies means that aggrieved party, that wounded party can suffer some losses. So for that wounded party, we give some compensation, those who are not in the default of the contract. So that is called as remedies for breach of contract. We are giving some type of remedies, either it is a monetary or non-monetary remedies. So remedies for the breach of contract means that it is a course of action available to the aggrieved party who is not in the part of the default. So there are 5 remedies. We can say that rescission of the contract, suit for damages, suit for a specific performance, suit for injunction, and suit for quantum meriota. We can say the first one, rescission of the contract. Rescission means it is cancellation of the contract. That is, two parties can mutually cancel the contract get automatically discharged. So that is called rescission. We can say that rescission is a legal term. In the English term, we can say it is a cancellation of the contract. Then second suit, which is called as suit for damages. Damages means that aggrieved party suffered some losses, no? So for that damages, we are giving some monetary compensation to the wounded party. That is called suit for damages. In that there are 4 types: ordinary damages, special damages, punitive damages, and nominal damages. And the third suit is suit for specific performance. Suit for specific performance means we can saying that we are approaching the court and asking for the demand of the compensation. That is called suit for specific performance. For example, we can say that is agreed to sell the old painting to Y. So on the agreed day, X refuses to sell the painting, means Y can go for the court and can suit against the X, that can ask for the claim or a compensation. That is called suit for specific performance. Then suit for injunction. Injunction means it is demanding the court stay order. We can ask, that is wounded party can approach the court and asking for that, getting the stay order for doing the particular set of the actions. We can stop the opponent party to do the particular act. That is called suit for injunction. We can say with an example, if the W want to sing at the L theatre, means during the contract period, W has a contract with the Z can to be sing in that particular theater. So L is expecting that the W can sing in our theater. So L is getting automatic suffered. So it is defaultly get suffered. So L can approach the court and make a action against W and asking for the stay order not to do the particular act of singing in the Z theater. That is called suit for injunction. Suit for injunction means we can stop the particular set of action, that is a party who is involved in the contract. Then a last one we can say that is suit for quantum merit. Quantum merit means it is as much as earned. So as much as earned means we can asking for the compensation as a part of the work which is already published or completed. We can asking for the compensation in the part of the work which has been already done. So we can say with an example, if the C is the owner of the magazine can engage to P to write a book and publish in an installment. Okay, so in a certain period of time it was published in the installment. After that the magazine stopped publishing. So that P can asking for the claim which is a part of the payment which is already published in the contract basis. So that is called suit for quantum merit. So for the earned which is the part of the work which is completed, they can ask for the compensation. That is called suit for quantum merit. Here in the conclusion we can conclude this topic in that we can give the remedies for the wounded party, and we can say that we can get the compensation and give the compensation to the injured party, not to punish the party. We should not at any cost need not be punish the party who is in a default. We can asking for the compensation. Next, the last we can exclude that it is a default. The defaulting party is need to be claim the damages or give some monetary compensation to the wounded party. So in this type of questions can frequently ask, that is a breach of the contract, a short note and types of damages. Then what are all the various remedies we can give that, and we can asking for the cases which is called as the damages to be. These are all the references book. Thank you.